call the meeting of the McHenry County Zoning Board of Appeals to order. The purpose for our hearing today is petition Z250105. It is a zoning interpretation appeal. The site address is 40 Brink Street. The parcel identification number is 0605100030. The street address is 25010 Illinois Route 173, Harvard, Illinois. Applicant name is Mark Saladin. Oh, Brink Street is
The office.
your office, yes, in Crystal Lake. And so the project description is an appealing the decision of the Director of Planning and Development dated October 30th, 2025, regarding the use of the property under the I-1 zoning district. At this time, I'll have the Zoning Board of Appeals members identify themselves in the township in which they reside, starting on my left.
Robert Cozen, Algonquin Township.
Mary Donner, Greenwood Township.
Charlie Eldridge, Richmond Township.
Linnea Kustra, Alden Township.
Vicki Gardner, Nunda Township.
Kurt Schnabel, Riley Township.
Jess Beverly, Door Township.
This petition has been reviewed and the following items have been received prior to today's scheduled hearing. Publisher's certificate of publication from a newspaper is dated January 7, 2026, and thereby meets ordinance requirements. A posted notice was not required for this petition. The affidavit of mailing was signed and the date mailed was December 24, 2025, and thereby meets ordinance requirements. A survey was not required for this petition. Filing fees have been paid. The endangered species consultation was not required for this petition, and the McHenry County Soil and Water Conservation District report has been received. This would be NRI 2511247773. This is a quasi-judicial hearing. Anyone giving testimony or asking questions will need to be sworn in. So at this time, anyone who wants to speak, I ask you to raise your right hand. Do you affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth?
I do.
I think you're all pretty familiar with the way the hearing works, so I won't go through that. I will just turn it over to you, Mr. Saladin.
Well, thank you, Ms. Kustra. My name is Mark Saladin. I'm an attorney in Crystal Lake, and I'm representing Seegers Limited, who's the owner of the property, and Northeast Illinois Rail Transport Company, which is a tenant on the property. And what we'd like to have is, because we know that in your role today, you are the judge, jury, and hopefully not the executioner today, but we understand that you can make a final decision on this matter. So what I'd like to have is a conversation, with you about kind of how we got to this point and what our concerns are, and certainly what Adam's concerns were when he was kind of confronted with this question. So just a little bit of history of this parcel. So in 2013, we came before this board and we got approved a rezoning, a map amendment, to zone the property from A1, which had an old conditional use for a golf driving range at that time. And we got it rezoned to I1. And during that whole hearing, there was testimony presented by Mr. Seegers regarding, the intended use of the property. And there was a reason for that intended use of the property because of the railroad tracks that were adjacent to the property, his existing grain elevators, which were on the other side of the tracks, as well as Illinois State Route 173. And during that, and Bob can testify to kind of what his testimony was back at that time. And we have, minutes that we've got, which were then presented to the county board. We had a unanimous recommendation from the ZBA at that time for the I-1 zoning. We had a unanimous decision by the county board for the I-1 zoning. And it was always our understanding of the use of the property would be for, what we were calling like a multimodal transportation hub, which products could be transported by rail, offloaded, picked up by trucks, and then go to a final destination. In addition, at that time, the grain elevator and that business would also benefit from it. So that was our intent, and that's certainly what we presented to the board. That type of a business on this property, and I-1 made the most sense. At that time, there was different staff members, a different, director. We were never told of any other avenue that we needed to pursue at that time. To say, no, you're gonna be a freight terminal, so you gotta get a conditional use. Never had that discussion in any meeting that we had with the county. So we went with the I-1, knowing we presented what we really wanted during that hearing. So I'm gonna have Bob just talk a little bit about, I think it's important to understand the railroad that existed. So Bob, why don't you tell us about, why don't you give us your name and address first for the record?
Okay. My name is Robert Seegers Jr., and I live at 688 West South Street in Woodstock. I am the president of Seegers Limited and Northeast Illinois Rail Truck Transfer Corporation, located at 25010 IL Route 173. You ready for me to?
Yeah, so, let's talk a little bit about, the business that you have, the railroad, who owned the railroad, what's happened over time.
Back in 13.
Yeah.
Okay, so our primary business, as a couple of you know, was the grain business. We had been in the grain business for 60 years. And the reason that we acquired this property and wanted to do this is we were trying to develop a rail-served industrial park in Crystal Lake. The Union Pacific Railroad, as you may imagine, is extremely difficult to deal with. The however is, we weren't just a gnat on an elephant's butt, because we did a lot of freight business in our grain business with the Union Pacific, $20 million a year worth. And so they listened to us. But however, on this rail-served industrial park, they said, this isn't gonna be for your grain business use, this is gonna be for other people's use. And so for the right to tie in a spur is a tie-in to the main line, where they can exit and service your business. They wanted $2 million for the right just to tie into the line. That's no track or anything. That's just simply for the right to tie into their main line. So what it was a major impediment to bringing industrial business to McHenry County, right?
Now, would that have been your facility in Richfield at that time?
Yeah, so that's the workaround, Mr. Eldridge. So what happened is we owned this 77 acres adjacent, and not really adjacent, almost adjacent to our property in our grain elevator in Richfield. So we had already had service for our grain company in Richfield, and this was right down Richfield Road. Well, what happened, this impediment, of course, knocked out the industrial park idea on Richfield Road. So, but what we said to ourselves is, look, we own a railroad, and our company owned it's still called the Chicago-Chemung Railroad Corporation, runs from downtown Harvard to the Boone-McHenry County line. It's a monstrous 3.5-mile railroad. And we said, look, if somebody wanted to come to McHenry County and start a business that would benefit by rail service with a $2 million at that time impediment by the Union Pacific to tie in, that's never going to happen. But we own a railroad. Why don't we acquire property adjacent to our railroad? And because we own the railroad, we don't have to say to somebody, hey, it's $2 million for the right to tie into our railroad. And so we also recognized, because our grain business was shipping containers of grain, soybeans in particular, down to Joliet area. Shanahan's the actual location. But on the Burlington Northern Railroad, we were hauling containers of grain every year, and we were watching products, all kinds of products, come back to McHenry County from that Shanahan location, from the Burlington Northern hub. And the products that were coming to McHenry County were lumber, plastic resin pellets, building materials, specialized rebar. And we said, if we did that up here, and that land is very expensive, in the hundreds of thousands per acre down in adjacent to that big rail hub. We could do it on cheaper land up here, lower the barrier to entry, and provide opportunity both for industrialized companies and McHenry County itself to be able to draw business. So we'd help ourselves, we'd help McHenry County, and we'd help a prospective user of those materials. And a big item we were looking at back then, and is still viable today, is plastic resin pellets. There are 15, or at the time I started this project, there were 15 plastic injection molding companies in McHenry County. All of them, the resin pellets are made at the refineries in the Houston area. And they don't truck them up here. They're all getting resin pellets from Houston, but they're being railed into the Channahon, Joliet area, being put on trucks. They're transloaded, like we wanted to do, and, brought up to McHenry County, where they're delivered to the end users, to the manufacturers. So this railroad idea, us owning a railroad, was in our mind a key barrier breaker, right, to getting that type of business up here to McHenry County. The railroad existed solely for the benefit of our grain company at the time. And in 2019, actually started in 18 but finished in 19, our grain company wasn't for sale. We didn't have a for sale sign. We didn't engage with any brokers to sell our business. We actually tried to buy another company's assets, and they said no, and the whole thing turned around, and they said, could we buy your assets? And we said no, because we weren't for sale, but the dialogue kept going, and one thing led to another, and we sold our grain company. A critical piece of the assets that they were buying was this railroad. They could not have their grain business without the Chicago-Chemung Railroad, so that had to be part of the sale transaction. And so back when we approached you in 2013, none of this was an issue, right? But now, in our business plan here at the Chemung property, we needed the Union Pacific beyond the Chicago-Chemung Railroad. The Chicago-Chemung Railroad was going to take our products or deliver our products 2 miles from what's called the junction of the Union Pacific in downtown Harvard, and then the Union Pacific would be the line haul carrier. Well, one of the problems that we encountered after, or when we were selling our grain company is, look, we've invested this money, been working on this rail to truck transload operation up here. You're gonna have to buy that from us. And they said, no, we don't wanna buy it. And I said, well, then you're gonna have to move our freight. So that developed another set of negotiations, right? But the railroad, the Chicago-Chemung Railroad, was critical to anyone located on that Chicago-Chemung Railroad line. However, as now we don't own it. There's another player involved. But that hasn't been the biggest problem for us.
Yeah, so let's talk about, so in 2013, we got the I-1 zoning, and you began, was there an office on the property?
There was I will call it an office. It was set up for a mini golf driving range pro shop.
Right.
Yeah.
So
Yes.
you were on site?
Yes.
Working there. Tell us a little bit about some of the things that you did to the property, investment-wise, that you needed to do in order to do your potential business.
Yeah, it took us about 2 years. The first part was demoing or demolishing the mini golf, the driving range facilities. They were cement, the mini golf thing that was cemented in the ground. Taking all the lights that illuminated the driving range field. There was netting on poles all the way along 173. Took all that down. And then in order, we didn't start stormwater work until we got the zoning, because there was no sense in us doing that. And I specifically remember at the zoning board hearing, the chairman at that time said, look, this is gonna be the easiest part for them. They're gonna have a harder time with the stormwater, and boy, I didn't imagine that to be the case. But we actually have more money in this complying with the stormwater permit than everything else combined. But what we did is we started on a 1.5 to 2-year project, demoing. Then we moved the entrance to the property to accommodate semi-trucks, had to deal with the state of Illinois, the Department of Transportation with the shape of our driveway, the permits, you guys know all that. We started changing the road work to allow for semi-truck traffic because the entrance for the putting, putt-putt golf, I guess I'll call it, I'm not sure if there's a technical name for it. The putt-putt golf and driving range was a vehicular entrance that wouldn't work for truck traffic. And we had to substantially expand the detention pond, right? Because the property, our property is flat, relatively flat. I think maybe there's 1 foot or 1.5 feet of variance over 24 acres. So the stormwater detention was expanded by 20-fold. And we wanted enough expansion in the retention so we could build a lot more permeable surface.
Impervious.
Impervious, okay, impervious surface. So we did spend a whole year doing the stormwater work. We had excavators, contractors. Then after the stormwater work got completed, then we put a rail siding in. So a rail siding is what hooks into the Chicago-Chemung Railroad track, crosses their property for maybe 100 feet or so, and then comes onto our property and then extends for a total of 900 feet to accommodate holding of rail cars.
What year was that?
15, 16, 17, in that period.
So from that time then, you were having ongoing negotiations even beyond 2017, am I correct, relative to trying to get this business started?
I started negotiations with the Union Pacific right after we got our zoning ZBA hearing approval here in late 2013. When you deal with the Union Pacific, it is an army of different groups. And so they said in late 2013, we can't even talk to you until you're set up and ready to go. So then we spent the next several years building out the operation, and that's when they go through their steps. They have to engineer what you've already engineered and installed and make sure that it meets their engineering requirements. And then, eventually sales and marketing get involved, and sales and marketing are worthless. But anyway, yes. But I was also starting to originate business, calling on, it took, there was several years of investigative work because not all products will work into here. It has to be something, one rail car, by the way, for the purpose of your understanding, is equivalent of capacity of 4 80,000-pound semi-loads. So I can't just bring in Brock's Candy because I am pretty sure I'm not getting rid of 4 80,000-pound semi-loads of Brock's Candy, right? So it's only going to be commodities or products that are used in a large enough quantity. So I started, that took, several years of investigating origins.
Yeah, so, as the board knows, the reason we're here, and we'll just kind of short circuit to that, is that you had an intention at one point, you had an offer for somebody to buy the property.
Correct.
Recently.
Yes.
Right? And unfortunately, that was a trucking business, correct?
Yes.
So when the trucking business went to the county to say, I want to house my trucks here, the county interpreted the ordinance to say, well, according to the UDO, that would be a freight terminal and you're not allowed to do that unless you have a conditional use in I-1. That gave us pause as a petitioner because that wasn't the intent Unfortunately, that maybe have been the wrong buyer, for purposes of coming before the county to ask that question, can I do the trucking business? So when I asked for an interpretation, because we were concerned about the intermodal transportation that we've already kind of established. And at that point, then Adam wrote his letter on October 30th. And, staff did the research as far as looking at aerial photographs and finding out what happened on the surface of the property, and not knowing all of the years of efforts that we were undergoing to try and get to the point where we could actually have business out there, where there would be shipments made and trucks picking it up and moving it. Is that correct, Bob?
That is absolutely correct.
So now we have this interpretation in a letter form from the director, which makes us very concerned about the business that we wanted to transact at this site. Let's put the contract aside that we ended up losing because of the idea that a truck terminal with storage of trucks and maintenance of trucks is a lot different than what we intended this property to be. And so, Bob, beyond 2017, you are continuing to work at trying to make this business start up. Is that correct?
Correct. And it was complicated wasn't complicated by the Chicago Schmung Railroad, because at that time we still owned it. The Union Pacific was the barrier. And we finally got through all of their departments, all of their approvals. They told me it takes years to start to be a shipper. And the truth of the matter is they don't really want a shipper they want a shipper like our grain company that's loading 115 cars at a time, doing it in 10 hours and doing it once or twice a week, right? And that's what the kind of business they wanted. The other thing that happens with the railroad is, just like geopolitics, cycles happen where they get less interested in doing business and then more interested, and those cycle times take years. So we were crossing one of their cycles.
So during this time then, you were unable to have actual physical transportation, at that time. Was it ever your intent, do you think, to ever have a truck terminal where trucks would be stored on site for a long period of time or maintained on site?
It was our belief that we were going to run our business and we would need maybe 1 or 2 trucks of our own, but generally going to hire all the product moved on hired trucks. We would just have 1 or 2 of our own in case, somebody made a promise that they couldn't deliver on, which was concurrent with our thoughts in the grain business. We had a few trucks of our own and hired everything else. But that wasn't our initial plan, not at all. But I think other people in this business would tend to have more trucks and supply the freight. Mark, you have a question?
Can I ask a question?
Sure.
So I thought I understood everything until we started talking about trucking. Are you asking for legal non-conforming use for a rail freight yard or for a trucking with storage facility?
Well,
Or for all of it?
Well, let's kind of back up, because I think this gets into the nuance of the problem that we're facing with this, is with the interpretation that we have, the petitioner's under the understanding that we're not allowed to do the business that we thought we were allowed to do when we got the I-1 zoning, which was the intermodal transportation, bringing in some product, storing it maybe for 24 hours, 48 hours, and having a truck pick it up. And that was kind of and that's what we presented.
Just to not deceive them. Bob Seegers, sorry. Initially, largely the product's scope would be that. We'd take it off of a rail car, arrange for truck freight to deliver it. But we were also looking at products that would stockpile in inventory, like road salt was one item. Fertilizer was another item. This, why we needed the impervious surface expansion, right? So there are some items that would be there more than
Okay,
24 or 48 hours.
sure. So, but when we got the zoning interpretation, in our mind, our use was cut off unless we came back in for a conditional use permit, which made no sense to us after we got the I-1 zoning at that time. The problem that I see is the UDO's definition. Now, the UDO came about in October of 2014, okay? We were unaware that this definition was out there because we had gone through the zoning, got the I-1. We thought we had everything that we needed to do the business that Bob has explained. But now with the UDO, the definition, and this, you know, Jessica, this gets to your question, the definition of freight terminal kind of combines a trucking business with the type of business that Mr. Seegers has outlined. Because it says, this is from the UDO, the freight terminal is a facility where commercial vehicles are stored and maintained. That's one part. But then there's the word "and," where cargo may be transferred from one transport vehicle to another or between modes of transportation, including rail, air, truck, or ship. That part of the business we thought we already had. The trucking terminal is a different issue.
I've got a question that is going to need an answer from Adam as well as you. Is that something I can do, Madam Chairman?
I think let's just wait till they finish so that
Okay,
the
'cause,
recording identifies who's asking the question.
Sure.
I think we need to do it as we traditionally do.
Okay, because,
Yeah. So
You need a pen?
no, I know this question.
So again, this is Mark
Whether
Saladin.
you agree on something or not.
This is Mark Saladin speaking. So the argument that I made to staff was, well, we have a non-conforming use then because you allowed it in 2013 and you changed the ordinance in 2014. So you must let us continue to pursue our use, right? And the interpretation came down that your use has expired because you have not done anything on the property. Well, aerial photograph wise, other than the stormwater improvements and the impervious surface improvements in the office building and Bob sitting in an office, the staff didn't know any of that, right? So it's all of those things that we've been doing to try and create the business that we anticipated that we didn't know about, that staff didn't know about. So that's why we appeal to you for that reason. But I think there's some concerns with the current definition of freight terminal, which kind of blends a trucking business where you're storing 15 or 20 semis and maintaining them on site, which really isn't the intent of this business, versus the cargo portion of that definition, which is what our business is. So we need help in interpreting this provision, and that's why we're here.
Okay, I'm going to start with questioning Ms. Beverly, if you have any other questions. for them.
Yeah, I have a bunch.
Okay. I'll just move down the line.
I'm just making a note. Hold on just a second. Okay.
Sure.
What would the specific hardship be with doing a conditional use permit or a map amendment to I-2?
The risk of getting an I-2 zoning in that area. I mean, there is I-1 zoning around, and plus, we've already gone through the cost and expense of having a zoning hearing and having a county board vote and having a zoning ordinance created that met the business that we wanted. So it's a hardship to us to have to come back through a process that we've already been through.
Adam, would this all be permitted by right under an I-2? And it wouldn't
Under an
be
I-2?
subjected to the CUP process?
Under an I-2 would be a freight terminal, as we've defined, then look at that use, it would be allowed by right.
And that would
conditional
come
use.
to you first, and the staff would make an interpretation on the standards for a map amendment. Is it your opinion that this would satisfy those criteria?
Well, I tell you what, we learned a lot of information today as we were discussing, as Mark and Bob had expressed that we weren't aware of, you know, in terms of that occupancy and all that. So I think I'd have to digest it a little bit more, but there's nothing right now that I would say, hey, this use would have to be corrected or something, a component of it that we would object to and wouldn't, you know, recognize if the forms were filled out, it would be a complete application that we'd be able to take forward. You know what I mean? There's nothing technically infeasible that I would be able to recognize that.
There's no red flag that says you wouldn't support an I-2?
I
If,
mean,
if you knew everything that you heard today when you made your first opinion, would it remain the same?
Yeah, yes, it would, for a couple of reasons. And actually, it kind of expands a little bit, you know, based on how it came to light. So we had a potential prospective buyer that was coming in that was asking for a use that, you know, certainly we didn't recognize out on site. And hearing how it's evolved or how it's been established over the last 13 years, it would have been a change of use compared to what it is now. So we would recognize using that section in the ordinance. It would deem that non-conforming use no longer valid, and proper zoning procedures or applications would be necessary in order to establish that new use.
So your opinion remains the same, that in order to pursue the use on this site, they would have to do a map amendment or a CUP under the I-1?
My interpretation, again, was based on the concept that there was this application for a trucking business that was gonna be out there that met our definition of a freight terminal. So that was the basis of that, or kind of that initial assumption was based on that type of use. Learning what that use is now, it changes a little bit, but I think my opinion would probably land in the same spot.
And if this board were to find that it's legal non-conforming, does that change anything about the department's ability to enforce anything on site? Like if it's legal non-conforming, does that change their rights versus having a conditional use permit or having the I-2 zoning?
No, it really doesn't. You know, I think the matter at hand is that the owner wants to continue doing at least continue what they've been doing. If there's a new owner or that use evolves, then, you know, then it goes right back to the change of use section in the UDO.
And how would you know that?
Exactly, right? I mean, how we didn't know what we learned today. We would be reliant on the same, you know, resources and aerials and documents or interviews and discussion points that how we come to learn or assemble any of our compliance cases or our reports.
And because it's not subject to a CUP, there would be no review process. You wouldn't randomly say, I'm gonna go look at this property and see what's going on?
Correct.
And so we implemented the CUP process and the time period limits in 2014 to establish some sort of review of compliance on site for activities that they're zoned for and all that.
Yeah, the conditional use are, you know, specific uses that may be more intense. They're allowed in a particular zoning district, but are recognized that they may have other impacts. And so that's where they go before yourselves and the county board for them.
And a CUP goes with the property in the event of a sale. So once it's there, it's there. And the time periods are determined by ordinance, but this board and the county board have been known to extend them beyond 10 years.
Correct, on both sides.
So if this was to be compliant with our current UDO, it would still be a saleable property and you would still be able to continue pursuing the garbage with UP North. Everybody, I think, that is operating an intermodal facility has a lot of complaints about all of the railroads, but in particular them. But even if this were to become compliant with the UDO and with staff's interpretation, you'd still be able to do everything that you're already doing.
We don't want to come back for a conditional use. Why do we need to spend the money to do a conditional use when we already were given that right under the original I-1 zoning? And the non-conforming provision that staff relies on, if you actually read it, it says if a non-conforming use is discontinued for a year. We never discontinued the use. The other part of it is that if a structure that it occupies becomes vacant and remains unoccupied for a continuous period of 1 year, that's not the case either. We still have the right to a non-conforming interpretation under the ordinance. That's our position.
It's your interpretation that you did not abandon the use at all.
Never abandoned the use. Our use was compliant with I-1. There's no reason to, now, take the trucking business out of it. that threw the wrench into the works. Now we're left with this decision which basically says we can't run our business unless we come back in front of you. And that's not fair. That's not what we bargained for when we came before you the first time,
13 years ago.
13 years ago. But we've had testimony that it's taken that long to get this business going.
And I wouldn't have spent, this is Bob Seegers, I wouldn't have spent well in excess of $1 million to this point to start the business just for the fun of hoping the county comes back and makes me come back and ask for something else that they might approve. That's foolish business.
Thanks, that's all I have.
Mr. Shaw,
Nothing at this time.
Ms. Gardner.
So where does your business stand right now? Are you still trying to get this business going? Is the business going? Are you trying to sell the business? Where are we?
So I'd like to, we're still trying to get the business going. We, up through the end of 24, finally we got a resolution because we don't own the Seegers doesn't own the Chicago-Chemung Railroad anymore. There's another party involved in the transactional negotiations, right? Operationally, financially, liability, you can imagine all of that. The fact of the matter is at the end of 24, we had finally come to a 3-party agreement between the purchasers of the Chicago-Chemung Railroad, the Union Pacific, and ourselves. And so now in 25, I've restarted calling on all the contacts I made. And I should add this, I don't think this means anything to you. It took me until 2021 for the Union Pacific. I had 5 departments of the Union Pacific on a conference call, and they approved what I wanted to do. And they said it would take 2 weeks to get documentation. In April of 24, they reneged on their approval because the legal department didn't like it, the law group, who was on the original call. So I waited for 3.5 years contacting them every week for 3.5 years. Where's our documentation? But it is, so now at the end of 24, in December 24, we finally got an agreement between the Chicago-Chemung Railroad ourselves and the Union Pacific. Chicago-Chemung Railroad's not a problem. They haven't been a problem. It's been the Union Pacific. We finally got that resolved, and I'm back recalling on the business I had lined up, because after we got our approval in 21, I had freight business lined up ready to do, subject to the paperwork for the Union Pacific coming, which never came. So
the
I am
short
still trying,
The short answer is you're
Yes.
still in that business,
I'm there
trying to
every
make
day.
it work.
I've been there every day in my office.
Okay, you're not trying to sell it anymore.
Can I address the sale piece?
Quickly.
Quickly. I had someone call, a realtor who saw a industrial piece of property sell for a high value somewhere else in the county and said, look, if you want to sell this property, this is what happened. I sold it in one day and I got 5 interested parties that didn't even get a chance to bid on this industrial piece of property. Would you be interested in selling? And I said, well, if I got enough money for it, like every other transaction, I'd do it. And it sold in one day. I got a contract in one day. We didn't sell because, and that I also would like
So
to.
you sold it or you didn't?
We signed a contract. That's the contract Mark referred to that busted.
Oh, so that did not go through.
That is correct.
Okay.
Because of this.
So let me ask you this. If somebody buys the property and wants to do something other than a freight terminal, which you should be grandfathered into, wouldn't it be incumbent on them to change the zoning to what it needs to be?
Correct. Yeah, I mean, if a buyer wants to buy the property, to use it with what the Seegers Limited and the Northeastern Illinois Rail Transport Company has indicated, they should be able to do that by right. Okay. Obviously, if they're going to change the use, then they're going to have to come back through the county through some process. So there's always going to be a potential process if someone changes the use, which I know Adam was talking about. If there's a change of use, different story. County's gonna come in and take a look at it, and, you know, they're gonna have to go through whatever process it is, either a rezone to I-2 or a conditional use permit. That shouldn't be us, though.
But if there is no change of use with a new buyer, there should be no problem.
We should be able to do what we've described here without any conditional use or anything else.
So in a nutshell, it seems like, as you see the problem, you've been actually working this business all this time, and it has been interpreted as abandoned,
Correct,
in which case you contest that.
correct.
Okay. I think I'm clear on the big points here.
Mr. Eldridge.
Yeah, who owns the Chicago and Chemung Railroad? Is it the DeLong Company or
Yes.
some entity of theirs?
Yes,
Okay. And you have an agreement with them?
yes.
You actually have a spur from them onto your property, is that correct? Or you have a right to put a spur on?
We already have a spur, we own the spur, it's just, it
So you
has
put
to
the spur on
cross.
before you sold the,
Yes,
the
yes,
railroad?
yes.
Okay. So that connection is existing and has been existing since 2014, 15, sometime in there?
Yeah,
16?
maybe 15, 16, 17.
Okay.
You know, it was near that, that was the last thing we did on the improvement of the property was put the rail spur in.
Okay. Adam, isn't the department's position that if they had continued that they had the use of right, and if they had continued it, there would be no issue?
Yes.
So that the only issue in terms of what Mark is asking for, not his potential buyer, but Mark today, is whether or not it was abandoned in the interim.
Right.
Do you still have an office that you go to on this site?
Every day. Yes, sir.
Okay. Is that your principal office at this
Yes,
point?
it is.
You have, at this point, you've done the demolition and the site work, you have the IDOT permission
Yes.
to operate the business that you wish, you have the stormwater
Yes.
work done, and all of that was, the physical work was completed 7, 8 years ago, 6, 7 years
16,
ago?
17, yep.
Okay, so since that time, it's really been arguing with the Union Pacific,
100% of the problem.
and you're not the only person that's that kind of argument with
I'm
the Union
aware.
Pacific. The basic issue with the Union Pacific, I presume, was the number of cars you'd be loading at a time.
Yes.
But if you were loading 50 or 75 or 100 cars at a time on a daily or weekly basis, there wouldn't be an issue.
I might suggest to you that, and for the benefit of all of you, that the railroads were given the land that they operate on by the government, right?
And a lot more next to their land,
Yeah,
too.
and a lot more next to the land. And by law, they are a common carrier, which means if anyone wants to ship on their railroad, they can't say no. They're not obligated to do it for a loss or for a break even, but they cannot say no. The Chicago-Chemung Railroad is also a common carrier. And by law, as a common carrier, has an obligation to provide freight service for anybody that wants to ship on their railroad. Again, not at a loss, not at a break even, at a profit. What the Union Pacific is very careful about dancing around is they're like an insurance company that owes you for a settlement because your house got blown down in a tornado. They do everything they can to not, they can't tell you no, but they'll do everything they can and hope they wear you out with time and money, right? And that's exactly what the situation is here for us. And they just underestimated my resilience.
And your mortality.
Mortality's getting closer. I was here 20-something years ago.
Anything else?
No, I think that are my questions.
Ms. Donner?
I think everybody blew my thunder. Those are all the questions I was going to ask. I guess not in statement form, but it would be true then that if somebody purchased your property and decided to do something other than what you've decided to do, then they have to come back to us. The question then is, how do we know that?
Unless they
And
meet
what-
the
and
I-1,
what do we do?
unless they meet the I-1 permitted uses.
Yes.
Yeah.
Okay. Mr. Cozen?
Thank you. This has very interesting and attractive, and I appeal first to the patience of the audience. And some comfort to be known that I found it curious that at the same time that you were seeking a working relationship with the Union Pacific, so did the Illinois Tollway Authority in 2013 to get western access to O'Hare, and I still can't get there in this time on that access. And that has a national significance, it occurs. So that brings me to the point in 2013, was there a definition that staff could point to as intermodal?
I don't believe there was.
So if a customer were to come in, or you, as you came in, how did you realize that you could create such a business on that property?
I'm going to give you the short answer is, when I went, Mark Saladin and Tom Zank, some of you remember Mark's partner, Tom Zank, I stood in their office and I told them what I wanted to do, and they said, you are never going to get it. You're going to go to the county, you're going to tell them you don't know what you're going to handle or what you're going to do, and you're asking for industrial zoning. You're never going to get it. So I don't know, maybe now you can, that's how.
Hand it over to you.
I am a little persistent, see?
Yeah, I think there was nothing in the I-1 permitted uses that we didn't feel that we could meet, given the type of business that he wanted, okay? And even if you looked at the definition of light industry, okay?
In 2013, because
Well,
that's the
okay,
birth.
so, yeah, I mean, but even today's definition of light industry talks about uses that include incidental storage, sales, and distribution of products.
Right.
You mean, so, and believe me, when I come to do a zoning project, as you know and as staff knows, one of the first things I do is call staff. Second thing I do is maybe have a meeting with staff to say, this is what we intend to do. How do you see this in your zoning ordinance? If there was anything at that time that would have pointed us into a conditional use or something else, we would have pursued that, but there's nothing.
So did you receive a demolition permit or a grading permit for the removal of the golf facility?
You know, you remember, Phil? I don't know. One of our other brothers handled that. I would assume we had stormwater, we had all the, yeah.
Stormwater. I was just looking for this proverbial signaling at somewhere up and down the line where staff would say, I wonder what's going on in this property. If you affirmatively, in your 2013 petition, waived your conditional use for the golf course. So you gave that away.
We did,
You
yeah.
gave that away. And that was an asset that you gave away, am I correct?
Correct.
And so then you sought, the record does not speak one way or another, that you sought to remain lawful to remove the golf course and all the lighting out there.
Correct, right, yeah, so it's the removal of the golf course standards, the netting, and then it became fulfilling the requirements of stormwater.
So what use did you reveal to stormwater that you were building this detention facility for?
I don't know that I know the answer.
Well, it would be the same.
What we asked for here at the zoning.
Yeah, it would be the same, that this is going to be a potential intermodal transportation. We need pads to be able to store this, which.
But where did you point to the use of the word intermodal in your application?
We probably didn't, it was during testimony. And during testimony,
So you used the word intermodal in 2013?
I believe we did. In fact, I believe Mr. Eldridge also coined that term for us at that time as well.
It
Yeah.
wasn't a new term.
No.
I mean, there've been intermodal.
Yeah, because we have
The
rail.
one at Rochelle had been established a few years before
And
that.
the whole idea was that because it was unique because we had the rail line as well as the state highway.
Right, but
Here was my testimony in
Please.
2013 to this body. Mark so graciously printed up pages of questions for me to answer under oath. His question was, please describe for us why this property is important to your business. And my answer was, it's a unique parcel between two significant modes of transportation, not in any urban or high-density residential area. We saw it as an opportunity to merge two modes of transportation for more effective and efficient use of the county's transportation system. That was my answer specifically to that question in 2013.
since we're sharing technical information, intermodal is a relatively new term. It didn't come about until 2018 to allow for certain containerization and standardization, notwithstanding the purchase of Canadian National and the EJ&E, which happened around the same time. So where you were, I can appreciate your testimony at that point. But going forward in 2014, what did you tell IDOT when you got your permit on the roadway and what you were building there?
We told them, I was involved in some of those conversations, at least specifically part we had to provide a performance bond. But we told them what the business exactly as I described to you, and we described to the ZBA in 2013 what we're doing, and we are gonna have, they initially wanted deceleration lanes, and we said, look, there's not gonna be that much truck traffic over a year's time. And so then they told us what they needed for, our driveway entrance is really unique. If you've been by there, it's really wide, so it has a quasi deceleration for a semi-truck.
It's certainly no
But-
longer a golf course
Oh,
or
no.
putting green or just
No.
then is there any state regulatory bodies that you had to appear before to run that and install that spur line, or is that
No.
something you just do on your?
Once we got approval from this board, we started the 2 to 3 year process of converting the property.
So the Commerce Commission doesn't enter a petition, there's no announcement of a new line?
No.
Nothing along that, so other than IDOT and the county stormwater
I
drainage?
take that back. I do want to correct my statement. At the time we owned the Chicago-Chemung Railroad, at the point we hooked up the spur to the Chicago, which was, we call it Northeast Illinois Rail Truck Transfer Company, we call it NEIL. So I'm going to use that, it's just a lot easier to say. When NEIL hooked up the spur, the Chicago-Chemung Railroad was obligated in the Federal Register of Station Indexes to note for the FRA that there's another station attached to this railroad.
And with an established mile marker along the road
Yes,
as
correct.
well,
Yes.
denoting along
Yes.
the entire location?
Yes.
I think I've learned enough about railroading, Madam Chairman. Thank you for your patience.
Okay. My question is, when you were working with Union Pacific, and then when DeLong bought the Chemung Railroad, did they use that to complicate matters? Is that?
No.
So
It
that
was,
wasn't an
what
issue?
complicated the matter is more about our agreement between us and DeLong trying to make this seamless for them. So what we didn't want to do, it wasn't, when we owned the railroad, it was gonna be almost zero burden on the grain operations people to move 200 cars a year, you know, a couple a week, right? And from Chemung to Harvard, and where we would hand them off. Almost none, but the DeLong company looks at things different than the Seegers company look at things. And so it was they didn't understand, they never had owned a railroad before, so they didn't understand FRA regulations and rules. And
What's FAR?
FRA is Federal Railroad Administration. So the railroad is, they have their own set of rules. They have their own railroad retirement, they have their own retirement system. There's union issues with railroads.
That's okay,
Yeah,
just
so-
to understand.
So DeLong, there was some manipulation or educating of the DeLong company to understand. They thought it was, why don't we just do this? Why are we talking about this? Right? Well, there's FRA compliance
So they
issues.
didn't understand the complications.
No, but one of my brothers still worked for DeLong, and he was the one that managed the Chicago-Chemung Railroad when we owned it. And so he took time to get them up to speed and understand the
That's good enough.
risk.
So my question is there any restriction now with DeLong as to who can use this stub railroad? So, I mean, you're granted that, but if you sold it to somebody else, would they still have the
No.
ability to use that railroad?
Our agreement with DeLong clearly stipulates that our rights are transferable. And as a matter of fact, this is such a solid deal that DeLong has a right of first refusal on our property, and we have a right of first refusal to purchase the railroad back. So, and that agreement is transferable to whoever subsequently.
So if
may
somebody
own.
came to you and wanted to buy your freight facility,
Mhm.
and continue this operation, they would still have access to
Oh, yeah.
that railroad. It wouldn't be any problem.
And even if for some reason they violated the agreement between my property and Chicago-Chemung Railroad, if they violated it, what that means is it's just gonna cost them a little more money because Chicago-Chemung Railroad is still obligated to provide freight service as a common carrier.
Okay.
It's just gonna cost whoever's doing it more money than it would under my agreement.
Okay. All right, that was my only question. Otherwise, I think I understand it pretty well. So now we'll just take any testimony from Adam. Anything else that you want to give us or, an interpretation based on the testimony you've heard today, what your feelings are and
Yeah.
any recommendation to the board that you would give?
Well, thank you. And I think there is a reality that, I don't think anybody would really argue, or I'm not arguing it, that something has been at this site, and it's been
So
invisible.
you're not saying it was abandoned now?
Based on this site, I don't think we have much of a way to demonstrate an opposing argument to anything that you've described in terms of what's there. And I've, gone back through Ms. Beverly's question a few times in my head and calling into question whether or not I really framed it that the basis of our interpretation was again back to the trucking operation. That would have been, and I would maintain that would be an introduction. It's different than at least what was described in that
So if
discussion.
they
It's
had
different.
come forward to you, you would have had, you have no problem with what is existing and
Correct.
don't feel it's been an abandoned use or anything like that?
Correct. The discussion point would never have come up.
And anything they continue to plan to do, as was discussed here today, you have no problem with?
I really don't. The only thing that I recognize is that in 2013, there probably would have been a much different discussion had. But that's water under the bridge. That's why we're talking about legal nonconformities. I think there would have been a different zoning action. So that being said, I'm comfortable withdrawing that portion of the determination that this existing use is not, or it would have been abandoned. I think that it is legal nonconforming at that point. But I do believe that the change of use, if and when it's sold, I think that would be something to really monitor as you go forward or as potential buyers come in. I think that won't catch anybody off guard. I think when you're starting to negotiate, and then on our end, I think it'll be pretty clear that changes may come, but They don't have to at this point.
So you're withdrawing your analysis?
On the basis of the trucking use, no. But on the basis of what was introduced today, then I would say we wouldn't have that challenge.
So what findings do we need to make as a board today?
Exactly. I think this is, yeah. Right. Again, based on the testimony that was provided today, we wouldn't have an objection.
Okay.
May I ask a question? Well, make a comment and then a question. This buyer that we lost, he was he had a trucking business, but he was intrigued specifically on our property about the rail service aspect and didn't know at his time of signing the contract how he might utilize that to enhance his trucking business, but thought to himself, I think I might be able to do that to generate more business for my trucking business. I'm assuming.
That's not a question for this board, though. This board is only the interpretation
Right, so-
and what you are doing currently.
So based on the interpretation aspect of what we're doing currently, I'm assuming that in that scenario, if a buyer came in who was a trucking business but going to use the rail transload aspect to complement their trucking business, would that not fall under legal non-conforming or not?
If that's all they were gonna do.
Right, that's exactly it.
Okay.
It would have to fit.
Got it,
Yeah,
okay.
right
Thank you.
within what you're doing.
Does anyone else have a question for Adam Mullen?
Is anything, now that we've passed the 2050 plan and there's going to be other changes made with UDOs and stuff, will any of that affect this
This
particular issue? My guess is it does not.
No.
But if everything changed, if they did it in 2013 and everything changed in 2014, and now we are doing something else that may change the UDO again.
But what
Where do they
passes the
stand?
comprehensive plan,
But we-
not a zoning.
Okay,
Right,
I'm sorry.
it's a different thing.
Yeah.
My only suggestion is that the definition of freight terminal in its present form causes concern. There's a separation there that I think we could talk about, and I'm happy to chat with you if we got to bring it in front of the county board as an amendment. If everybody agrees, that would be great, but I think there's a distinct difference between a company that's a trucking company that's going to store 20 semis out there and have maintenance versus trucks that come and pick up stuff, after it's been shipped. So that's, because right now, that's what's causing the concern. And I think that's Bob's
But that's
question.
not before us today.
That's not before you today. Okay, so procedurally though, I want to make sure that, I made an appeal to this board. Now, are we good with just the director withdrawing his?
No, we're going to vote to.
Okay. Yeah, I would like an
with the-
affirmative motion.
Yes,
Yeah.
we're going to make an affirmative motion, at least I am, to.
Well, or
I'll
someone
join you.
else.
Yeah.
Oh, and when does that happen?
Well, when we're done talking here and we
Yeah.
go to a voting meeting. Does
To
anyone
conform
else
with
have
what the council
All right, thank you.
anyone have any other questions for Adam? Do you have a closing statement?
Thank you very much.
Thank you.
Succinct.
So at this time, we'll close the hearing portion of this and we'll move on to the voting portion. So at this time, I would entertain a motion to, an affirmative would be in the petitioner's favor, that we would overturn the opinion of the zoning enforcement officer.
Madam Chairman, I move that we modify the determination of the zoning enforcement officer to the extent that petitioner remains a legal non-conforming use to the extent he simply wishes to pursue the business that he advocated when he came in for I-1 zoning, which is an intermodal, but that other trucking activities and things that constitute a freight terminal, we affirm the decision of the zoning enforcement officer.
Is there a second?
Second.
Okay, moved by Mr. Eldridge, second by Mr. Schnabel. Before we continue, I just want to ask staff, so we're able to do something like that? We don't have to completely approve or completely deny, we're able to modify this in this
Race into
fashion?
that definition right
It
now.
does say it can be modified.
Yeah.
Explicit.
Yeah, the ordinance allows you to reverse, affirm, or modify the determination.
Okay, excellent. Okay, discussion, Mr. Eldridge.
Yes, I think testimony here has demonstrated to my satisfaction and apparently to staff's satisfaction that what's was permitted in 2014 or 2013 remains a legal non-conforming use, but that the apparent desire of a former contract purchaser went well beyond what that legal non-conforming use was and is not permitted without a conditional use going forward. So we are modifying it to the extent, to that extent, so the petitioner can continue to use, try to promote the business he's been trying to promote since the zoning change took place 12 years ago. And we find that he has continued that use uninterrupted, at least up to this point, although a lot of that is seeking to do business rather than making physical changes to the real estate. But that is entirely sufficient to void the issue of abandonment, at least in my view. And for that reason, I am going to vote in favor of the modification I've proposed.
Okay, so what I've written down is, to just kind of summarize a little, we're modifying the opinion in favor of the applicant and that their use has not been abandoned, but the opinion on other uses listed by the zoning enforcement officer are valid.
That's correct.
Okay. Ms. Gardner, any discussion?
I actually remember that hearing in 2013 and your business model and how you presented it, and I thought it was good. And I am feeling your frustration over these many years. I agree that if you have indeed been doing something at that business, trying to get it going all this time, that you should be grandfathered in. And so my vote will be yes.
Mr. Cozen?
I'll be supporting the modification. Specifically, I finally understand the spur line we that is have kept me from going directly to one of my favorite Chinese restaurants in Crystal Lake, and to whom and how it is served. But also, I too have a concern, and I believe the modification addresses it, in terms of trying to grant some prospective approval going forward, given the vagaries of both land use over time and so forth. So again, I'll be supporting this petition.
Mr. Schnabel?
I will support the petition as well.
Ms. Beverly?
I concur.
Ms. Donner?
I've had to deal with UP at UP Northwest when I worked for Pace Suburban Bus. Nothing ever goes slow. So I appreciate what you've been dealing with and the fact that the modification is probably the most efficient way of taking care of it. I will be supporting this petition, modification.
And I'll be supporting this as well, so I'll call for the vote. Mr. Eldridge?
Yes.
Ms. Gardner?
Yes.
Mr. Cozen?
Yes.
Mr. Schnabel?
Yes.
Ms. Beverly?
Yes.
Ms. Donner?
Yay.
And I'll vote yes, so this will go to the county board with a 7-0 vote on this.
No
modification.
this
County
is-
board.
this is-
Oh, no.
You are
No, we
the-
don't have to go. We have to prove
You
this.
guys have power.
Oh, my God. So this,
Bring 'em on.
this
It's
modification
done.
opinion stands.
Thank you so much. I really appreciate the conversation because it